Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hi, everybody. Welcome to Inheritance Solutions for a Diverse Community with Richard Hall, founder of Bottom Line Lawyers. Richard combines extensive legal and real estate expertise to help clients with estate planning and to protect their families' futures. Richard, thanks for joining us.
Thanks, Matt. Happy to be here.
All right, so we're on to episode 2. We're going to be discussing estate planning fundamentals. Let's jump right in. What are the fundamental components of estate planning, and why is it crucial for individuals and families to have a well thought out estate plan?
So a basic estate plan consists of 5 components. There's a pour over will, and the pour over will does exactly what the name implies. Anything that you own at the time of your passing pours over into your trust. And the purpose for that is to make sure you have one instrument that disposes of all of your property. Now, the exception to that, of course, is real estate, because real estate must be deeded into the trust and cannot come into the trust only through a pour over will. The next, obviously, is the trust itself. And the trust has a variety of different components: naming the trust, establishing who the trustees are and the successor trustees are, who the beneficiaries are, and many, many provisions that we add into that deal with your specific family situation. And then there's a power of attorney for financial purposes. And in a power of attorney, I should make clear that it's called an agent for power of attorney. In a trust, it's a trustee. In the will, it's called an executor. They're all different names. They all mean essentially the same thing. So an executor, an agent, and a trustee all do essentially the same thing. And the next component is a power of attorney for healthcare purposes. And finally is a HIPAA release. And the HIPAA release allows people whom you want to get information about your health situation to get that, even though statutorily they would not be permitted to get that information from a hospital or a doctor. So those are the 5 pieces that go into most estate plans. There can be additional things depending upon your circumstance. But it's critical that there's a well thought through estate plan, because it obviously, well, maybe not obviously, but it saves a lot of money and a lot of heartbreak after losing a loved one. It makes the process much simpler. But the main thing is it takes the focus off of the stuff when someone passes and puts it on the quality of their life and what they contributed. And so people can then really focus on their relationship with a loved one who's passed and not be focused on the things that they acquired during their life.
Yeah, it's amazing, like you were saying on our last episode, how much people can change during these traumatic events. And I guess they're going through so much as well. So you're combining a potential death in a family and then the management of complex assets. To that point, I want to ask you, what are the primary differences? And you touched on this a little bit, but the primary differences between wills and trusts in estate planning, and when is one more beneficial than the other?
It's a rare day that I'd recommend a will only. That a trust is a far better instrument for 99% of estate planning. And a lot of folks don't understand that a will doesn't give you benefits with a piece of property, real property, that you would get in a trust. And even a will must be probated. And that means you're going to go to court. And that means you're going to pay probate fees. And probate fees can be very substantial on an estate worth, $700,000 or $800,000, which in today's market, if you have real estate and a few other things, that's pretty easy to do. That could run $80,000 versus a trust, which is 5% of that. So it's a radical difference that way. But there are still uses for wills. So in estate planning, we use wills. For instance, that's one place. If you're parents and you have minor children and something happens and you pass prematurely and your children are still minors, someone has to take care of them. And this is where in the will we specify who's going to take care of them. And if you don't do that, then it's going to be a judge. Now, a lot of respect for judges. They are smart and they have a lot of compassion, but they don't know your family. They don't know what's better for your children. They don't know your values. And frequently I hear people, I wouldn't want my brother to raise my kids. And the way you avoid that is by specifying that in a will. Also in a will, I usually urge people to dispose of, so to speak, specific items. So dad has a 65 Corvette that he wants to go to his grandson. Don't put that in the trust because it might have to be liquidated in order to pay fees or whatever. So put that in the will. Or mom's got a wedding dress and she wants that to go to someone in particular, or a wedding ring. That's the sort of thing that we put into the will. And so it doesn't even make it into the trust. It's just taken care of right off the bat.
That's actually a very interesting point. And how do you distinguish what goes into the trust versus the will? I'm assuming there are some gray areas in there at times.
Well, there is, but the general rule would be if you don't want it liquidated, that is to say, you don't want it sold and turned into cash, put it in the will. And if you don't care if it's liquidated, then put it in the trust. And that goes for your savings account and other types of investment accounts. Although I have to correct myself. For most people, if they have a minor savings account and a minor checking account, I don't recommend putting that in the trust or the will. I recommend that they do what's called a POD, pay on death. That makes it easy for your survivors and beneficiaries to access the money that's available there to pay bills while you're waiting for a trust to be administered. Even a trust will take a number of months to administer, not as long as a probate, which may take 2 or 3 years. But in the meantime, bills still need to be paid. Simple from electric to phone to whatever have to be paid.
Can you detail for us why a trust can help avoid probate and the potential advantages to avoiding the probate process in estate administration?
Well, remember, probate is essentially a court process. And what that means is somebody other than you is making decisions about your property. Even if you have a will, there's going to be interpretation of that will, and that's going to be left up to a judge who doesn't know you from Adam. And so you want to have the maximum amount of control over your estate, who gets what and what happens. Then it's best to have that in a trust where that can be administered. But also in a probate situation, because it's court, it takes time. It's more open to challenge than a trust is. We usually put provisions in for no contest, both in wills and trusts, but they're more effective in a trust than they are in a will. And of course, the expense is a major factor. Probates can be lengthy, they can be very combative, they're disruptive to family relationships. So, it's not the ideal method. Now, I handle a lot of probates and I'm happy to do so. But I give you a very pertinent example that's sad, but we have a client that came in last fall and we drafted a full estate plan for them. They dithered and never signed it. And now that client has died. And so they're dying with an old will in place and no estate plan. Going to make a big difference for their beneficiaries and a big difference in the management of their estate.
Richard, can you discuss for us the privacy advantages of a living trust over a will?
I'm really glad you asked that question because most people think they want to name, I'm going to have a trust. I'm going to call it the Richard Hall Family Trust. I think that's a bad idea. The whole idea of a trust is privacy. And if you have your name on it, it's not very private, is it? And trusts have been around for hundreds of years, and the wealthy have used them for hundreds of years to, shall we say, secrete their wealth. And if you have a deed that puts a property into the Richard Hall Trust, well, you kind of know who owns that property. On the other hand, if it goes into the XYZ Trust, then it's less obvious for sure. Not that it can't be ascertained through other means sometimes, but let's not make it easy. It's kind of like, only give out your Social Security number to people who need to have it, and only give out the last 4 digits when you can, and that ensures your privacy. So a trust doesn't get recorded anywhere until all the trustors have passed. And even then, it may not need to be recorded. When one trustor passes, that trust becomes, at least as to their portion of it, becomes irrevocable, so no one can change it. And once the second trustor, assuming it's like husband and wife situation or partner situation, once the second person passes, then the entire trust is irrevocable and cannot be changed.
So you just touched on this, but I want to elaborate a little more. So a living trust, how does it help facilitate the smooth transfer of assets to beneficiaries when a grantor is incapacitated or passes away? And then what steps should individuals take to ensure that the trust remains effective in these situations?
You have two things going on there. One is if the trustor has become incapacitated, usually what's going to happen is the power of attorney is going to kick in. And the power of attorney is going to allow that person to make the financial decisions and take the financial actions necessary on behalf of the incapacitated person. And that incapacity could be permanent or it could be temporary. Somebody went into the hospital and they had surgery, and maybe they had an accident and they were put into a medically induced coma. Well, then they are no longer possessed of legal capacity. But once they come out of that, then they would be, and that can go back. That power is back to their power.
So what steps should individuals take to ensure the trust's effectiveness in these situations?
Well, the most important step they can take is make sure it's a well-drafted trust and make sure that the individual that they appoint as an administrator or a trustee of that trust is competent to do so. I usually ask that, in a typical situation with a couple, whether it's same-sex couple or husband and wife, whatever it is, that they are each trustees when we form the trust. When the first one passes, then the successor takes over as the successor trustee. The survivor takes over. And then when the survivor passes, then it goes to a new successor trustee. I usually suggest that you have, if you can, 3 levels, because sometimes a trustee that you've appointed either can't or won't fill that role. And so if they can't or won't, let's pass it to the next person. If that person can't or won't, let's pass it to the next person. And if you don't have someone in there in those optional spots, then you've got to go back to court and get the court to appoint someone. And that just costs money and takes time.
Interesting. So bouncing around a little bit into taxes and tax implications, what are those benefits of a living trust when it comes to taxes?
Well, first, let's say that for most people ask me about estate taxes. And unless you have an estate for a single person more than about $13 million or a couple, $26 million, you're not looking at estate taxes. But you could very well be looking at capital gains taxes. And capital gains taxes can be very significant. So having your property in a trust creates a stepped up basis for that property. And that's not just real property. That's also, you might have gotten Apple stock in 1980. It's now worth a lot of money.
It's a lot of money now.
Yeah, it certainly is. And the basis in that, if you paid maybe $50 a share, and now I don't know what the trading price is today, but it's astronomically higher than that. And there may have been splits of stock along the way. Without the benefit of the trust, you're going to pay capital gains on the difference between the acquisition price and the sale price. With a trust, you're going to get the benefit of a stepped up basis and pay tax only on the difference between the value at the time the trustor passes and what you actually sell it for. Most of the time, because the sales happen relatively quickly, there's no tax at all. So that's one aspect, and it's certainly true for real estate. The other thing to be mindful of, at least here in California, we recently passed Prop 19, which is a proposition dealing with the property tax assessment on real estate in a trust. And it's, in my humble opinion, it's a little hinky. But what has to happen is if someone in the family is going to inherit that property, they need to move in to that property within 1 calendar year of the passing of the trustor in order to make the property ineligible for a reassessment. Otherwise, property is going to get reassessed, and somebody has been in the home for any period of time. They know they had Prop 13 benefits, and they're paying $2,000 a year in taxes, and it's going to go to $2,000 a month in taxes if it gets reassessed. So it can be significant. So that's the biggest benefits in terms of taxation. The other thing that can be done is you can split a trust into pieces if necessary. We don't do that so much anymore, but there's the survivor's trust and the trust of the person who passed, right? And so we can split up when the taxes are paid, which means they're going to pay at a lower rate than they would on the entire estate. That's Another choice that gets made in drafting a trust is, do you want, if you've got 5 beneficiaries, do you want the taxes apportioned across all of those so that each beneficiary pays the tax on their amount, which could be a burden for them and they may not be able to meet that. On the other hand, because it's a smaller amount, it's going to be a much lower amount. The rate of tax is going to be lower. On the other hand, if you say, well, I want the estate to pay the taxes on everything, that makes it simpler for everybody. It all gets taken off the top, but it may be at a higher rate because it's got the entire value of the estate being taxed.
Makes sense. Can you highlight the potential time and cost savings associated with administering a living trust versus going through the probate process with a will?
With a well-designed trust and with no contest, usually we can be done with the administration in 6 to 8 months. There's a period of time that's going to be required, usually about 4 months, to get the notice out to people and give them an opportunity to challenge the trust if they have any issues. And then there's what we call marshaling the assets. So that's really about making sure we know what all the assets are, and all that, although that may seem obvious to most people, it's frequently not. There are people I've known that they opened up, oh, look in that cupboard, and there's some stock certificates that go back to 1930. You've got to find all of those assets and inventory those assets and value those assets, and then see what the distribution calls for, and then do an accounting. And sometimes the accounting has to be approved by the court, and sometimes the beneficiaries can waive the accounting if they feel like they've gotten sufficient information. So all those things together can take 6 or 8 months. But if there's a trust contest, then it can go substantially longer. One of the detriments of having co-trustees, I can give you a case out of my own experience where co-trustees were appointed and they couldn't agree, so they had to go to court to get an answer, and that went around and around, and one of the trustees simply wouldn't perform at all. And we ended up having to make a motion in another county to get that trustee removed. The trustee was removed. Then we went to mediation and finally got the thing resolved. But that was probably 3 years after the trustor had passed.
What are the biggest misconceptions or myths about living trusts? How can people better understand their limitations and their possibilities?
That's a good question. I think the biggest misconception is that once you do it, you're done. And that's simply not true. Every trust should be reviewed either every 3 to 5 years or whenever you have a major life event, a marriage, a divorce, a birth, a death, someone goes off to college, someone retires. All of those things can trigger different concerns in your estate plan. And so whenever those events occur, that the contents should be reviewed. And the 3 to 5 years is because the law changes. I will mention that I don't do a lot of trust amendments. I do what are called restatements. And so if you want to change your trust, we do a restatement of the entire trust. It means you don't have to change the name and you don't have to retitle assets and things like that. So it's less costly to do so. But certain provisions have to be repeated, either an amendment or a restatement. And a lot of people will make an amendment to a trust and fail to restate the specific things that are required by law, such as a spendthrift clause, such as a no contest clause. And they go to administer the amended trust and find out, oh, yeah, people can attack that trust because there is no contest. There is not a no contest clause anymore because it went through an amendment and that wasn't restated. So I think that's the biggest area of concern.
What advice do you have for people who are considering a living trust and the role it can play in securing their financial legacy and their family's future?
Think of Nike, just do it. Really and truly, not to be facetious about it. It's far more important to get it done than to get it done perfectly. Trust can be amended or restated. You can change things as you go along, but you can't correct the fact that you never did it in the first place when it was needed. And there are times when there are sudden and unexpected deaths, untimely deaths, and you want to make sure that the folks that you want to benefit from the work that you've performed over the years, they actually get that benefit. So it really is a matter of, take the action, get it done. I don't know if you saw the movie Barbie, but there's a scene in that movie where everybody's happy and go lucky and all that. And somebody asked Barbie, well, what are you thinking about? And she says, death. And the movie gets dark and collapses, and it's like, forget it. Nobody wants to talk about that. I wish I had that for a commercial, because that's what happens. People don't want to think about their own demise. And I don't blame them. It's not my favorite topic either. But it's far better to deal with it and know that it's taken care of. And then you don't have to fret about that aspect of the end of your life. You can focus on the quality of your life, which is far more important to most people. Better get something in writing and have it there. And like I say, it's like the great American novel. You can write it and then you can rewrite it and you can amend it and add some more, do whatever. You can do that. But if you've never written it in the first place, nobody's ever going to read anything. So there is no set of instructions. By the way, I haven't mentioned that I call it a set of instructions. Our typical estate plan, by the time you're done, is about 110, 120 pages. It's lengthy. However, the way we prepare them, there's about 10 pages that summarize all of the things that you've specified. And that's what you need to review and make sure that the names and the intentions are expressed. And the rest of it is the legalese that we've drafted to empower those things. And so I tell everybody, you're welcome to read the whole thing, especially if you have a little insomnia going on. But otherwise, just make sure you review the summary and confirm that everything's correct.
No, but that's valuable for people to know that it's accessible, because I think you're right. I think a lot of people feel intimidated. Like, I did not want to have this 100+ page document that I have to check in with. But you're right. If you have that outline, they can get the essentials without having to necessarily dig into all the legalese every time. So as we wrap up, I want to ask you, we've covered a lot here. If you had just one key takeaway for people, what would that be?
That it's not as challenging as you think it is to create the estate plan. Working with a professional, ask the right questions, it becomes pretty simple what has to happen. Do think about what you want to name your estate plan, your trust in particular. Lots of people, I'll give you a couple good laughs. People have named it after the mascot of the school they went to together. People have named it after their favorite line in a movie. I had a couple who had teenage kids who, whenever they'd say something, they would say, yeah, but what? And yeah, but they named theirs the Yeah, But Trust. Nobody knew what it meant except them, but they knew what it meant. So it can be more lighthearted. It can be very enervating and energizing to take care of it. And I have a habit of telling people, well, now that your trust is done, you're going to live for 100 years. That's just the rule of thumb, right?
Right. Well, you've removed all that stress, hopefully, right? So
exactly,
a couple of decades. Yeah, for sure. That's great. Well, Richard, thank you so much for your time. To everybody, thanks for listening to Inheritance Solutions for a Diverse Community. For more information, find Richard Hall on social media. Also, be sure to visit bottomlinelawyers.com. Richard, again, thanks for your time. Awesome conversation.
Thank you, Matt. My pleasure.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.